some. Are you going to skip over those? Or?
Yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions, one before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage, another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Burchmoore. There are certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Burchmoore. The parallels in these 2 cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Burchmoore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Burchmoore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Burchmoore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Burchmoore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Burchmoore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Burchmoore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request, objecting to it, particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Burchmoore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Burchmoore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Burchmoore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Burchmoore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Burchmoore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor.